Hello, everybody. So it's 12 o'clock. We did have a few more people registered for this than 10 or 12 or whatever. So let's give it a minute before we get cracking.
Yeah.
Can everybody see the slides there? Hopefully people can. If not, somebody put in the chat.
Some thumbs up.
Cool, brilliant. Okay, well, yeah, let's get cracking then. So I'm David. This is Ellie.
Hello.
And we are going to be talking to you today about technology and surveillance in the workplace, and probably only going to be 20 minutes or so, something like that. So it's not going to be the full half an hour. I'm not going to pan it out just for the sake of it. This is the agenda that we're going to be talking about. So how technology is being used to monitor employees, reasons for workplace monitoring, legal considerations on workplace monitoring and employee privacy, how employers can implement technology responsibly, and noteworthy employment tribunal cases. Of course, obviously, everybody's got to have their cameras on for this so that we can monitor whether or not you pay attention. We have got the technology set up to ensure that eye movement is focused on me and Ellie throughout this. You know, I hope you're all enjoying that dystopian reality. Just to let you guys know, we won't be sending out slides just because of the nature of this webinar being what it is. But we do offer training, bespoke training to businesses on various topics, including sexual harassment, disciplinaries and grievances, and so on. And there'll be details at the end as to how you can contact us about that. So my chair keeps going down, so if I get shorter, then that's what's happening. So how is technology being used to monitor employees? So there are numerous methods of surveillance which have evolved over time as a result of technological developments through which employers can monitor their employees. Those include telephone use, though some employers will track telephone usage in terms of call volumes and associated costs. In sectors where telephone communication is integral to client relations, calls may be recorded to evaluate employee performance, to maintain quality assurance standards, and ensure compliance with legal and regulatory obligations, particularly in highly regulated industries such as financial services. So there might be monitoring at various levels, including general organisational checks of usage patterns, without targeting individuals, such as websites, frequency of visits to particular websites, volume of emails sent and received, and call duration. There might be individual monitoring, so targeted surveillance of specific employees. That might be, for example, for disciplinary purposes or performance management, monitoring utilization, the number of calls that people are doing, for example. Also, there might be content monitoring and reviewing the substance of calls or emails, either randomly or on an individual basis. That again will be checking, generally speaking, for compliance and also possibly for performance management processes. With emails, advanced software can scan the content of employee emails for flagged keywords or suspicious destination addresses. That might be the case, in fact, even if emails are deleted from a user's computer, because they might be stored on the hard drive and recoverable using forensic tools, even once an employee has left. Internet usage might be monitored, and that might be in particular to restrict access to certain websites, or to identify the amount of time that people have been spending on sort of internet shopping and that sort of thing whilst during their working hours. And then also, and this has been quite sort of controversial, and particularly I think has come to the fore since the pandemic, when businesses started to work from home, and then perhaps those who were more reluctant to allow that, but there was no other option, and were perhaps less trusting of their employees to get on and do their work, might have implemented tools to monitor activity, specific activity on devices, such as keystroke logging, mouse click tracking, and screen recording or screen sort of eyesight monitoring. Obviously, as soon as the technology was developed to monitor, for example, mouse click tracking, the technology was developed to get around that system by, for example, buying a mouse jiggler, which I'm told, I haven't got one, but I'm told that you can get those online, and that'll confuse any tracking software that is monitoring whether or not you're using your mouse. Physical tracking, of course, as well, not using sniffer dogs in this day and age. So it might just be by wearable devices or vehicle-based trackers that record location and movement data. Typically, that won't be covert surveillance. Typically, that'll be something employees know about, and it's usually for safety reasons. CCTV and video surveillance, so surveillance cameras might be installed in workplaces. Again, generally that's going to be overt. It might be covert in certain circumstances where it's being used to detect or prevent crime or misconduct. There's no specific legislation in the UK that directly governs employee monitoring. Employers are neither explicitly authorised nor prohibited from conducting any particular type of surveillance. Instead, as the various methods of monitoring have developed over recent years, so has the regulatory framework governing their use. So as we'll go on to discuss, there are various legal considerations for employers to take into account when using technology to monitor employees.
So there are numerous reasons for workplace monitoring. So employees' use of phones, email, internet services, including social media platforms and blogs, can potentially lead to issues affecting performance and productivity. Employees' technology use may also result in reputational harm to the employer and could lead to loss of their business and expose them to various legal risks, such as harassment and discrimination, defamation, transmission of confidential information and trade secrets, accidental formation of contracts or breaches of contract, copyright infringements, hacking, transmission of viruses, and employee negligence. So employers may also implement monitoring practices to safeguard health and safety, comply with regulatory requirements, such as those in financial services sectors, or to enhance data protection and security measures. However, employers can only lawfully monitor employee activities, including where they wish to prevent liability arising in certain circumstances, which we will go on to discuss.
Okay, so legal considerations on workplace monitoring and employee privacy. So electronic surveillance in the workplace involves the processing of personal data, which is governed by the GDPR and the Data Protection Act 2018. So employees are entitled to be informed about what data is being collected, how it is used, who has access to it, and how they can challenge or object to its use. Where appropriate, employers must obtain informed and explicit consent to lawfully monitor employees. But consent isn't the only lawful basis, of course, of processing personal data. In cases of covert monitoring, an employer may rely on legitimate business interests, provided this justification outweighs the employee's right to privacy. So any personal data collected through monitoring must be processed lawfully, fairly, and transparently. So any business doing so will be expected to document their justification and approach to monitoring, typically by way of a data protection impact assessment, DPIA, initialism bans. The DPIA helps ensure the monitoring is necessary, proportionate, and appropriately assessed. Transparency is usually going to be essential, so in maintaining a clear and accessible employee privacy notice outlining monitoring practices is key. Covert monitoring is only lawful in limited circumstances, such as where there's a strong justification for investigating suspected misconduct, as I say. Non-compliance with data protection obligations can result in enforcement action, can result in complaints by people affected, and there can be significant fines involved or compensation potentially payable to individuals affected. The use of AI tools in employee monitoring is increasing. Obviously, the use of AI is increasing across the board. Number of grievances and employment tribunal claims we see that have clearly been written by AI is quite significant. I was reading a claim form the other day from an employee who was a specialist in AI, and I thought it was quite enlightening to note that the person who was the expert in AI had clearly not used AI in order to draft their claim form. But it's people who think AI is the solution to everything who drafted it. But anyway, that's an aside. Yeah, AI in terms of employee monitoring, be aware that those tools carry risks of bias, risks of discrimination, particularly when used to inform decisions such as performance reviews, bonuses, or disciplinary action. There's currently no standalone AI regulation in the UK. It's being developed separately to EU regulation, which I think may have already come into force. But use of AI will still fall under data protection law, and of course will still fall under general employment law principles where applicable. So to ensure fairness, it's generally expected that human oversight is included in any decision-making process involving AI. And if you think about it this way, if you can't explain how a decision was made, how can you explain that that decision was fair or non-discriminatory? And that could be failing if you're unable to properly explain that. So employment law, depending on the circumstances, an employer's monitoring activities may breach the implied duty of mutual trust and confidence in the employment contract. I think probably on its own, using things like keystroke monitoring and mouse monitoring isn't going to do that, particularly where people have been informed about it. But it certainly doesn't demonstrate that you as an employer have trust and confidence in your employees. That's a different test, but it's not going to engender that employee trust and confidence, in either direction. So if there is a breach of trust and confidence, depending on the circumstances, obviously that could give rise to a claim for constructive unfair dismissal by an employee with more than 2 years service. Employees who feel they've been unfairly targeted by monitoring may also bring claims of unlawful discrimination. Now, those claims may well not be sound in the sense that just because you've been treated unfairly doesn't mean you've been discriminated against. But if people feel that they have been treated unfairly, feel that they've been singled out, unfairly targeted, then that could lead to discrimination claims. And as I say, if you can't then explain the decision-making process, if the AI company you bought your software from is telling you we can't tell you how it works for sort of commercial reasons, stay away. You need to know how it works. You need to know how those decisions have been made and how that data has been collected. If evidence of misconduct is obtained through potentially covert monitoring is misused during an investigation or disciplinary process, any resulting dismissal could be deemed unfair. There's also the laws on the interception of communications, which may apply in the employment relationship. So employers might need to be aware of the statute regime governing the interception of electronic communications, which since June 2018 has been set out in the Investigatory Powers Act and the Investigatory Powers Regulations. So with certain exceptions, the Investigatory Powers Act makes it an offence for employers to intercept communications over its workplace telephone and computer networks that are attached to public telecommunication systems, which most will be, unless they have lawful authority to do so, which usually employers are probably going to be able to do so, i.e. demonstrate they've got lawful authority. In this context, lawful authority generally means obtaining the consent of both the sender and the recipient of the communication. So that's why you might see in employment contracts or policy something to say, well, we may monitor your email usage or phone usage, whatever it might be. There are exceptions where consent isn't required, though, which includes legitimate business activities, which would include the detection of unauthorized use of the employer's systems. The right to privacy should also be factored in. So Article 8 of the European Convention on Human Rights protects an individual's right to respect of private and family life. when a public authority considers taking action that may interfere with this right, it must apply the principle of proportionality by identifying a legitimate aim, ensuring the aim is sufficiently important to justify limiting the right, and confirming that the method used is no more intrusive than necessary to achieve the objective. Now, even if you are not an employer that's a public authority, an employment tribunal is. So when an employment tribunal is deciding any issues in terms of particularly perhaps unfair dismissal and whether monitoring has been proportionate and appropriate, the employment tribunal will be applying those principles. There have been cases where companies have been found to be, or employers rather, have been found to be in breach of that. So there's Halford against the United Kingdom, and that arose from not a claim against the United Kingdom, but a claim against the employer, and this was the employer's police service. So breach of Article 8 was found when a police inspector's office telephone calls were intercepted without her knowledge. One of the phones had been designated for private use, giving rise to a reasonable expectation of privacy. But at the time, there was no UK legislation regulating the interception of internal calls, meaning the interference was not in accordance with the law and therefore violated Article 8, the right to privacy. It's a case of Barbulescu against Romania. I went to Romania on holiday this year, but I don't know if that is the correct pronunciation, so apologies to any Romanian people listening. Again, this was the European Court of Human Rights. They held that Mr. Barbulescu's dismissal for personal use of the internet at work, despite strict company policies, was not justified. The court emphasised that an employer's instructions cannot reduce private social life in the workplace to zero. It also found that Mr. Barbulescu had not been adequately informed in advance with the monitoring about the monitoring communications, the extent of that monitoring, or the possibility that the content of his messages could be accessed. When considering whether monitoring is proportionate under Article 8, our employers should therefore take into account the following factors. So 5 things. Firstly, is the employee being clearly informed in advance that monitoring may occur and about the extent and nature of that monitoring? 2, what is the extent of the monitoring? What is the degree of intrusion into the employee's privacy? So is it limited in time? Does it cover only the flow of communications or their content? Or are all communications being monitored or just some, and is access restricted? Thirdly, does the employer have valid reasons to justify the extent and nature of the monitoring? Fourthly, could the employer's objectives be achieved through less intrusive methods that do not involve full access to content? 5, what are the consequences for the employee being monitored? And a bonus one, actually 6, which is on a different page, which is why I said there were only 5. Does the employee have adequate safeguards to prevent unauthorized access to communications?
So on to noteworthy employment tribunal cases on this topic. So first, City and County of Swansea versus Gales. This is 2013. So in this case, the Employment Appeal Tribunal ruled that the dismissal of Mr. Gale, who was a council employee, secretly filmed playing squash during working hours, was not unfair, overturning an earlier tribunal decision. So the key facts: Mr. Gale was seen playing squash during working hours on multiple occasions. The council had hired a private investigator to conduct covert surveillance, which confirmed the misconduct. Mr. Gale was then dismissed for gross misconduct and brought claims for unfair dismissal and race discrimination. So the initial tribunal decision, the tribunal accepted that the council had a genuine and reasonable belief that Mr. Gale was defrauding the council. However, it found that the covert surveillance was unjustified and disproportionate, breaching Article 8 of the European Convention on Human Rights, the right to privacy, and the Data Protection Act of 1998. And as a result, it ruled the dismissal unfair, but no compensation was awarded due to Mr. Gale's contributory conduct. The claimant then appealed, and the Employment Appeals Tribunal overturned the tribunal's decision, holding that the surveillance was not relevant to the fairness of the dismissal, as the misconduct was already established. Mr. Gale was filmed in a public place so he had no reasonable expectation of privacy. The council was entitled to verify his whereabouts during paid working hours, and so they found that there was no breach of data protection in this context. So key points to note for employers are that covert surveillance may be justified where there's clear evidence of misconduct and the employee is in a public setting. However, employers should not treat this case as a blanket approach for surveillance. Proportionality and necessity remain key. Legal advice should be sought before undertaking covert monitoring to avoid breaching privacy or data protection laws. So next, in Manjang v Uber Eats, the claimant, who was an Uber Eats driver, received financial settlement after alleging that the AI-driven facial recognition system used to verify drivers on the app was racially biased. The claimant brought claims for indirect race discrimination, harassment and victimization in October of 2021. The claimant, who is Black, was repeatedly locked out of the app after mismatches in automated ID checks, which ultimately led to him losing access to work and his income. His case was backed and funded by the Equality and Human Rights Commission and the App Drivers and Couriers Union, as they were concerned by the use of artificial intelligence and automated processes in this case, particularly how it could be used to permanently suspend a driver's access to the app, depriving them of an income. The case challenged what the claimant described as being dismissed by an algorithm. Whilst this case settled, it highlights critical risks for employers using AI in HR and workforce management. So key lessons from this case for employers include that it is important to be able to explain how an algorithm reaches its decisions. Human oversight is essential, especially when making final employment decisions. Algorithms learn from data, and biased data leads to biased outcomes. Diversity and inclusion need to be part of AI development, not an afterthought. And finally, Lanuska v Accountancy MK Services Limited, 2024. The claimant, who was an accountancy administrator at Accountancy MK Services, was awarded over £14,000 for unfair dismissal after her employer used spyware to monitor her computer use and dismissed her for allegedly spending time on personal activities during working hours. The key facts of the case were the spyware recorded 1 hour and 24 minutes of personal use over 2 days, but the tribunal found that this was not excessive and personal use was not prohibited by company policy. Some work-related activities were wrongfully classified as personal use by the software, and no disciplinary hearing was held. The claimant was summarily dismissed without a chance to respond. The employer failed to follow proper procedures, including the ACAS Code of Practice, and the tribunal found the employer intended to dismiss the claimant before she reached 2 years service, mistakenly believing she was not eligible to claim unfair dismissal, even though she had more than 2 years service. So the legal findings were that the dismissal was procedurally and substantially unfair. There were no reasonable investigation or evidence of misconduct. The employer's actions were outside the range of reasonable responses. The tribunal awarded a 20% uplift for failure to follow the ACAS Code of Practice. So key lessons from this case for employers include that occasional personal use of work devices is not automatically misconduct unless clearly prohibited in policies. Monitoring must be proportionate, transparent, and supported by clear policies, and employers must ensure fair procedures and accurate understanding of employee rights, including their length of service.
Okay, cheers, Ellie. So, final substantive slide. So, monitoring employees, obviously, it's not inherently unlawful, might amount to a breach of privacy, data protection, if you fail to comply with legal requirements. So to help ensure legal compliance, make sure you've got clear workplace policies implementing or setting out the nature and scope of any monitoring activities. Might be separate policies for CCTV or vehicle tracking. Be transparent generally, clearly communicate what's being monitored, why and how, provide employees with an up-to-date privacy notice, avoid hidden or covert monitoring unless strictly necessary. Where appropriate, obtain consent through the employment contract or a workplace policy incorporated into that contract. Make sure you're carrying out data protection impact assessments, which should also consider whether or not there are less intrusive alternatives available, and ensure fairness and human oversight. And just another case example illustrating what problems can arise where there isn't that human oversight, or there's a perception that there isn't that human oversight, was the cosmetic company Estee Lauder. So they settled with 3 makeup artists who'd been dismissed in part by an algorithm during redundancy exercise. They were informed that to reapply for their jobs by way of a video interview, and that video interview was analysed by AI software, analysed their answers, their facial expressions, and other data regarding performance. Following the interview, they were all informed they were being made redundant in part due to the algorithmic decision making. So they complained of a lack of transparency and the fact that when challenged, their employer was unable to explain on what basis they were being made redundant. That's what they said. The company defended its position, and they said, actually, we only used the algorithm for a quarter of the marks, and it was used in tandem with human decision making processes. But they settled, as most cases do. But clearly, the people involved felt that there was fairness inherent in that AI, particularly because the use of that AI, particularly because they felt it wasn't adequately explained by their employer. So make sure that HR managers are involved in any decisions, and then obviously, providing training and to managers and staff on responsible technology use. Don't let managers go wild and start monitoring employees however they want. Promoting a culture of trust, accountability, and ethical awareness is obviously key. So, should you need advice on any such issues, we do know some employment lawyers that you can contact, and that we offer a retainer service, the benefit of which, one of the benefits of which, is that if there is a tribunal or special project or anything, then there's 10% off our usual hourly rates. It provides access to the team, direct access to the team via email, phone, whatever method you want, and obviously within reason. But usually email, phone, Teams call, whatever, and also access to a bank of documents such as template contracts and guidance notes and FAQs. And there we all are with our contact details. And no, those photos haven't been downloaded from a modelling agency. That is actually what we all look like. It's absolutely mad, isn't it? So thank you to everybody for today, coming along today. Enjoy the rest of your day.
Thank you.
Cheers, guys. Bye.
Bye.